I'm not going to go into too much detail here about how the lawsuit got moved between various law firms. You can read about it on the link below at the drsydneyhollin.com/lawsuit link. In any event, Fuchsberg and Fuchsberg originally had the case, and then it was moved out by my personal attorney to the law firm of Friedman and Eisenstein. Ted Friedman was a well-known medical malpractice attorney at the time, and the case was being handled by his associate, Jethro Eisenstein. On August 2nd, 1985, Mr. Eisenstein filed lawsuit against Dr. Hollin's estate for medical malpractice and wrongful death. As it turned out, Ted Friedman ran into some legal problems of his own, so he and Mr. Eisenstein split up and the case went with Ted Friedman. Apparently his legal problems were insurmountable, and after 2 years he essentially had done nothing to further the case. So I called up Fuchsberg and Fuchsberg and asked them if they would take the case back. I spoke to Mr. Douglas, and he told me that if I agreed to pay $2,000 for an expert witness's opinion, they would take the case back, which I agreed to do. I met with Mr. Douglas, I believe, in December of 1988, signed a retainer agreement, and gave him a check for $2,000 payable to Fuchsberg and Fuchsberg. Mr. Douglas started working on the case in January 1989. Now, when he took over the case, I sat down with him and I explained to him the major facts that were known at the time. And we had also obtained, the medical records, and I had them in my possession and was able to review them, and it indicated pretty much what Dr. Hollin was up to here. Now, Phyllis didn't see Dr. Hollin within the 2.5-year period, as I mentioned. Her last appointment was 2 years and 10 months. So naturally, the attorney for Dr. Hollin's estate, Kathleen M. Beck, who was working for the law firm of Martin Clearwater and Bell, made a motion for summary dismissal, saying that the statute of limitations had expired. It expired 4 months previous. Preston J. Douglas then filed his response to her motion for summary dismissal, and these are basically his legal arguments in the case, and I am going to read them from start to finish because they are not really very long, and then we can dissect his legal arguments the same way he apparently dissected frogs in order to get his biology degree. Preston J. Douglas, an attorney duly admitted to practice law in the state of New York, affirms under penalty of perjury. This affirmation is submitted in opposition to the motion for summary judgment based on the defendant's allegation that the statute of limitations had expired at the time of the commencement of the within action. The within action arises out of surgery performed by the late defendant in 1975 and follow-up care which continued through and beyond the last visit of June 10, 1981. It is conceded that the last time Phyllis Press saw the late defendant Sidney Hollin was June 10, 1981. At that time, she was 6 years post-surgery in which Dr. Hollin had repaired 2 aneurysms in Mrs. Press's brain. By 1981, Mrs. Press was married and Dr. Hollin gave her a clean bill of health. He directed her to return for routine follow-up in 1 year. It is clear that at the time of the June 10th visit, the patient and the doctor contemplated a continuing and continuous relationship. It is plaintiff's claim that part of this continuing and continuous relationship mandated that Dr. Hollin use modern techniques to ascertain the status of the surgical repairs he performed back in 1975. In fact, the repairs were doomed to slip and open. When the repairs failed on April 5, 1984, Phyllis Press died. Defendants suggest that we should start the running of the statute of limitations clock on June 10, 1981. However, intervening events in which Dr. Hollin gave advice and continued to act as the continuing treatment physician carried the continuous treatment forward until at least January 20th, 1983. Phyllis Press gave birth to a child on November 1982. This full-term baby was conceived in or about February 1982. Prior to conception, Phyllis Press and her husband Ralph Press, the plaintiff herein, consulted with Philip Bresnick, MD, an obstetrician. This was in early 1982. During the pregnancy, Dr. Bresnick consulted the late defendant Hollin about the wisdom of continuing the pregnancy and was told that Phyllis did not require further treatment for the old aneurysms. After the delivery, once again, Dr. Bresnik consulted with Dr. Hollin and was told Phyllis Press did not need follow-up. Thereafter, in January 1982, Mrs. Press began exhibiting some bizarre symptoms which we believe may have been related to the beginnings of the reactivation of the aneurysms. She complained of severe neck and shoulder pain to her general practitioner, David Papier, MD. After consultation with Dr. Hollin, Dr. Papier prescribed anti-rheumatoid medication, Cliniral, for which we have the prescription, copy annexed as Exhibit A. Interestingly enough, Dr. Hollin's notes for his last visit on January 10, 1981, do not include the words advised CT scan in our copy of the records. We do not know when the alteration took place, but in point of fact, Dr. Hollin should have advised a CT scan before, during, and after that 1982 pregnancy. He should have told Drs. Bresnik and Papier when they asked that Mrs. Press needed a CT to assure the stability of her aneurysm repairs. Plaintiff considers that these consultations and advice by Dr. Hollin were part of his continuing treatment and his recognition of continuing responsibility for the patient's neurosurgical care. Plaintiff also considers that the alteration which Dr. Hollin made to his records was his recognition of a failure to advise the patient needed a modern test to check his work, which test was not available back in 1975. The alteration was made out of guilt, and it was made long after June 1981. The unaltered and altered copy of the records are annexed for comparison by the court as Exhibit A. Plaintiff suggests that this court might consider the late alteration of the record in and of itself to be an admission that Dr. Hollin considered himself continuously treating Phyllis Press. The original unaltered record was obtained by Mr. Press, see his affidavit, on or about March 14, 1984, when Phyllis Press was hospitalized dying of the recurring aneurysm. Oddly enough, Dr. Hollin died on March 13, 1984. However, on December 20, 1982, after the baby was born, Dr. Hollin sent an altered photostat of his records to IDS Life Insurance, apparently recognizing his error in follow-up. In any case, the defendant's dependent on the CT suggestion note in the moving papers is obviously misguided in view of the real facts. Since Phyllis Press died on April 5, 1984, and since her pregnancy was less than 2.5 years prior to the date of death, the consultations before and after her pregnancy were well within the statute of limitations of 2.5 years. Therefore, Phyllis Press died possessed of a cause of action for conscious pain and suffering if she had survived. The wrongful death action, brought much less than 2 years after her death, would therefore be timely. She died April 5, 1984, and the summons and complaint was served on August 21, 1985, by admission of the defendant. Wherefore, it is respectfully prayed that the within motion be denied in its entirety. That is the entire legal argument that was submitted by Preston J. Douglas. As far as the falsified CT scan document is concerned, what Preston J. Douglas is referring to is the fact that Kathleen M. Beck, when she filed her motion, pretended that the falsified document was real. In other words, she made believe that Dr. Hollin actually did advise a CT scan and that it was Phyllis's fault for not having it. So that's what he was referring to in terms of that. Now, the first thing we notice when we read Preston J. Douglas's legal arguments is it's difficult to believe that he's even talking about the same doctor and patient whose medical records we just reviewed. The second thing we notice is that he has explained absolutely nothing about what happened to Phyllis. You don't have a clue as to what her specific diagnosis is. You don't have a clue as to what Dr. Hollin did during the surgery. You don't even know what the official cause of death is because Preston J. Douglas didn't even submit an autopsy report as evidence. Failure to submit an autopsy report as evidence in a wrongful death case is suicide for the case and for obvious reasons. In order to prove wrongful death, you have to prove the doctor caused the patient's death in the manner outlined in an official autopsy. Without an autopsy, you don't know what the cause of death is. Just because a patient has a history of cerebral aneurysms and was operated on and then dies years later of a cerebral hemorrhage doesn't mean it was necessarily caused by the original surgery or that it was even on the original artery. They could have had a cerebral hemorrhage on an artery in a completely different part of the brain. That's why this type of general explanation is completely useless. It's basically just an opinion of what Preston J. Douglas thinks. I mean, what happened to all the evidence, you may be wondering? So, according to Preston J. Douglas, Dr. Hollin repaired 2 aneurysms, and in the statement he had me sign, it says using 2 different methods. So according to Preston J. Douglas, the operation is legitimate neurosurgery, and therefore, the entire malpractice was Dr. Hollin's failure to advise a CT scan at Phyllis's last appointment on June 10, 1981. You may be wondering, how is it possible that an attorney could possibly think the operation is legitimate when there is a consultant's report in the file that indicates Dr. Hollin lied to the consultant, telling him he just clipped the aneurysm, indicating that Dr. Hollin intentionally surgically mistreated the smaller aneurysm by wrapping it in order to preserve it and delay its growth on the artery? Well, let me explain it to you this way. It turns out that Preston J. Douglas, for 2 whole years that he had to prepare this case, didn't even bother to read the Mount Sinai medical records. The very first thing an attorney is supposed to do when he takes over a case is read every medical record in the file. That is the minimum mandatory required amount of work that needs to be done. And Preston J. Douglas didn't do it in this case because at the time the case was pending and he made his legal arguments, that document was not known to exist. I discovered it in 2007. I had the medical records in a file folder in my closet, and I was cleaning out my closet, so just for the heck of it, I decided to read it. About halfway through the file, the Mount Sinai file, was the consultant's report. It only took me maybe 10 minutes to locate it. It was sitting there for all these years, waiting to be discovered. To read the entire Mount Sinai file, I don't think took me 30 minutes, if even that long. So that means for the entire time that Preston J. Douglas had to prepare the case, he didn't spend any time reading the Mount Sinai medical records. And that's why his legal arguments read the way they do. But the fact of the matter is, we don't need the consultant's report to see what Dr. Hollin was up to. It's still totally obvious as to what he was up to. I mean, Mr. Douglas was fully aware of all the other medical records, that Dr. Hollin lied to Phyllis and told her she had 1 aneurysm, that Dr. Harupian said the operation was a time bomb, that Dr. Klein filed 2 falsified records, that Dr. Hollin ran to the Xerox machine. I mean, the other evidence was overwhelming, not to mention other witnesses that were available. And you'll notice Preston J. Douglas didn't provide a deposition from a single person. First of all, we have Dr. Harupian. He obviously should have been deposed to get a statement regarding the time bomb effect of the operation. Based upon his explanation, there is no way this could be a legitimate operation that Dr. Hollin repaired 2 aneurysms. An operation that makes the condition worse by promoting the growth of one of the aneurysms so it eventually ruptures and causes the death of the patient can hardly be legitimate surgery, that's for sure. The purpose of the surgery is to cure the patient, not cause him to drop dead on the spot years later. It is incomprehensible as to how Preston J. Douglas did not depose Dr. Harupian to get a statement in writing, but then again, it's incomprehensible as to how he didn't even bother to read the medical records. Then we have the other 2 surgeons. Obviously, they knew that the smaller aneurysm was supposed to be clipped, and Preston J. Douglas was fully aware that Dr. Klein filed a falsified discharge sheet and a falsified hospital report. Again, it's incomprehensible as how he didn't depose him, ask him why the smaller aneurysm wasn't clipped, and confront him with his falsified medical records. Because that's what real attorneys do. They depose adversarial witnesses and confront them with their falsified records. Unfortunately, the only real attorney that worked on this case worked for Dr. Hollin's estate. Then we have Dr. Wanser. He was an intern, but he also had to have known the smaller aneurysm was supposed to be clipped. After all, they were using the microscope. It was as big as daylight. He didn't file any reports, but he kept his mouth shut. The fact of the matter is, under proper questioning, both of these doctors would have been forced to admit that that aneurysm had to be clipped. And then, of course, we have Dr. Anton, the radiologist. He also knew the smaller aneurysm was supposed to be clipped. He'd seen enough aneurysms on angiograms to know which can be clipped and which can't. And also, standard procedure was to re-angiogram the patient 4 days after the operation to make sure that the aneurysms had been obliterated. That was not done in this case, but it had to have been discussed with Dr. Hollin. In all likelihood, Dr. Hollin told Dr. Anton that since they used the operating microscope, there was no need to put the patient through any more tests or procedures because he was certain that he had clipped the necks of both aneurysms. Of course, Dr. Hollin couldn't afford to have another angiogram done because then Dr. Anton would have seen he didn't clip the aneurysm. So we don't need the consultant's report, and as you could see, there were numerous witnesses that knew the smaller aneurysm was supposed to be clipped, and Preston J. Douglas didn't oppose a single one of them, and these are all totally obvious witnesses. Mr. Douglas was fully aware that there was a serious question as to why that aneurysm hadn't been clipped. You would think he would have deposed them all. Nope, he didn't depose anybody, period. So, according to Preston J. Douglas, all those medical records that we reviewed, all those lies and blatant misrepresentations perpetrated by Dr. Hollin, according to him, it just adds up to another ordinary case of negligence. What's so unusual about any of this? Apparently, Preston J. Douglas must believe that this is standard procedure for doctors. You will notice he doesn't mention at all that Dr. Hollin lied to Phyllis and told her she had one aneurysm. As a matter of fact, in the statement he had me sign, he twisted that around into me finding out later on that she had two aneurysms repaired using two different methods. So in other words, according to him, that's perfectly legitimate activity. Now, by failing to mention this, Mr. Douglas has legitimized Dr. Hollin's actions in the matter. He has legitimized the fact that it is perfectly acceptable for a doctor to lie to a patient for 8.5 years about a diagnosis and treatment. Remember, this happened back in 1975. Medical records weren't available like they are today, where you just sign on to your doctor's website and get them, or they even hand them to you as you're walking out the door sometime. Back then, in many instances, only attorneys can get medical records. So Phyllis and her immediate family and the personal physicians and even hospital personnel completely relied upon Dr. Hollin's fraudulent and malicious representation that he either had clipped the single aneurysm or he had clipped both aneurysms. Mr. Douglas makes no mention of this whatsoever. So this apparently to him is perfectly legitimate. He has also legitimized the fact that the patient doesn't have a right to know what a true diagnosis and treatment is. Phyllis died from the rupture of an aneurysm that was growing on her artery for 8.5 years that she had no idea whatsoever was even diagnosed or treated. Anytime she complained to anybody of the symptoms, even directly to Dr. Hollin, he said it had nothing to do with the operation. She was perfectly fine and even told it was safe to become pregnant. Preston J. Douglas apparently sees absolutely nothing wrong with that scenario also. Preston J. Douglas has also legitimized the fact that a surgeon has the right to insert foreign substances into the patient without their knowledge or consent and on a non-emergency basis, in this case muslin. Dr. Hollin wrapped the smaller aneurysm with muslin without Phyllis's knowledge or consent. And this wasn't an emergency procedure. It was premeditated and planned out. He had his diagnosis of the two aneurysms, and he got a clip and a piece of muslin cloth ready to plant the time bomb on Phyllis's artery. So, since Preston J. Douglas doesn't mention this at all, and this is the equivalent of her husband finding out later on that she had two aneurysms, then obviously Preston J. Douglas believes that it is perfectly acceptable for a surgeon to lie to a patient for 8.5 years about a diagnosis and treatment, and then deny that the symptoms she's exhibiting from his operation have nothing to do with the surgery, when in fact he's making the condition worse. That it is perfectly legitimate for the patient not to know what a true diagnosis and treatment is and be kept in the blind. Phyllis died from the rupture of an aneurysm that was growing on her artery for 8.5 years. She had no idea it was even there. She doesn't know. She never found out later on anything. She never found out what her ultimate cause of death was. And Preston J. Douglas has legitimized the fact that the surgeon has the right to insert foreign substances into the patient on a non-emergency basis. Of course, all three propositions are totally idiotic, and you couldn't find another person in the world that would think that that is somehow legitimate medical procedures. And you can rest assured if some doctor ever pulled a stunt like that on Preston J. Douglas or one of his relatives, he'd be screaming bloody murder. But when it happens to the client's wife, oh, Dr. Hollin didn't lie to her, you found out later on. Now, Preston J. Douglas submitted exactly 3 pieces of evidence. He submitted Dr. Papier's clinical prescription, the second page of Dr. Hollin's checkup sheet, the original that doesn't say advise CT scan, and the one he sent to the life insurance company that does say advise CT scan. That's all the evidence he provided in this entire case. Now, you will notice in his legal arguments, he's using consultations that Dr. Papier, the family doctor, and Dr. Bresnik had with Dr. Hollin. Well, As we reviewed, Dr. Bresnik took detailed consultation notes when he spoke to Dr. Hollin, yet Preston J. Douglas didn't submit them as evidence. Now, does that make any sense at all? Here he's using a consultation that the obstetrician had with Dr. Hollin as a critical piece of his legal argument. He has detailed consultation notes by the obstetrician. He doesn't even mention that they exist. It doesn't make any sense at all, except in the context of Preston J. Douglas's legal arguments. That's because, according to Preston J. Douglas, Dr. Bresnik's notes don't say what they say. We reviewed them. Dr. Hollin told him 3 lies and made 3 major omissions. But according to Preston J. Douglas, Dr. Hollin reassured Dr. Bresnik that the repairs were holding up. Yes, that's what that represents to Preston J. Douglas. You'll notice there is an ongoing pattern of him rewriting every fraudulent and malicious act. If Preston J. Douglas actually thought that Dr. Bresnik's notes represented that, he would have submitted them as evidence. But it's clear that they don't, and that's why he didn't. If he starts submitting that, the judge is going to see there's something wrong here. There was no reassurance of repairs. He was told a single aneurysm had been resected. This is how Preston J. Douglas rewrote the entire case, twisted the whole thing around, and single-handedly butchered and destroyed it without any consideration whatsoever for the actual documented facts. Obviously, Dr. Bresnik and Dr. Papier both should have been deposed, and he didn't depose either one of them. Not only that, he used Dr. Papier's prescription to represent the consultation that he had with Dr. Hollin. This is just another example of how little work he did on the case. If he's going to use a consultation that these doctors had, they obviously should have been deposed, and the judge would fully expect to see depositions. Instead, what does he see? He sees no evidence of a consultation from Dr. Bresnik. The judge doesn't know that those notes exist. All he sees is Dr. Papier's prescription, which is a joke. To submit a family doctor's prescription, which is supposed to represent a consultation he had with the defendant, is a joke. It's laughable at best. But it's obvious. Preston J. Douglas can't depose either one of these doctors, because if he does, he doesn't want to hear what they have to say. What they're going to tell him is, it's obvious from Dr. Bresnik's notes. If Dr. Hollin told Dr. Bresnik he resected a single aneurysm, you can rest assured that's exactly what he told Dr. Papier, and that's not what Preston J. Douglas wants to hear. That doesn't fit in with his reassurance of repairs nonsense, and that this somehow adds up to ordinary negligence. Furthermore, using a prescription from the family doctor in a case against a neurosurgeon, it's a joke. He didn't even use Dr. Hollin's falsified Mycilin prescription entry. I mentioned that to Mr. Douglas, that he falsified his Mycilin. And what did Mr. Douglas do? As soon as I mentioned that, he immediately changed the subject as to whether I was aware of any further appointments Phyllis had with Dr. Hollin. In other words, no thought went into ever as to why would Dr. Hollin even be falsifying a prescription entry. All that matters is, are there any further appointments and the 2.5-year statute of limitations? Because what Preston J. Douglas did was, instead of carefully reviewing the facts in this case, he superimposed his own methodology on the case. There is only one way to handle a case. Read the medical records and depose witnesses. Preston J. Douglas didn't do either one of those functions. In other words, he didn't perform any of the functions that an attorney needs to do to properly prepare a medical malpractice case. His methodology is based upon negligence, incompetence, ignorance of the law, laziness, and his desire to nickel and dime the case to death. This is how Preston J. Douglas apparently prepared the case, if you even want to call it. He didn't read the medical records, so he didn't know about the consultant. He didn't depose any of the doctors that I mentioned that knew the smaller aneurysm was supposed to be clipped. So what does he do? He went ahead and he contacted an expert witness he knew, a neurosurgeon, an unnecessary expert witness that I paid $2,000 for, and he provided him with incomplete medical records because he didn't get the consultant's report. Based upon the medical records he did have, and I spoke to his expert witness, he couldn't conclusively say that the smaller aneurysm was supposed to be clipped. Well, that doesn't mean it wasn't supposed to be clipped. So what does Preston J. Douglas do with this information? Well, he naturally assumes what's best for Dr. Hollin and what's worst for the client. He assumes that somehow legitimized the wrapping procedure, that Dr. Hollin repaired 2 aneurysms using 2 different methods. Now, you would think with all the other surrounding circumstantial evidence, such as lying to the patient, lying to the obstetrician, 2 doctors falsifying medical records, that red flags would be flying. Obviously, something isn't right here. No, not as far as Preston J. Douglas is concerned. He sees nothing wrong with any of this. It's just another ordinary case of negligence. Mr. Douglas, unfortunately, is totally hung up on his 2.5-year fixed statute of limitations nonsense, and he can't get past it no how. That's the problem. What he does is he just superimposes his own methodology, which is totally incompetent. Obviously, this attorney doesn't want to do any actual work. And what's really unbelievable is at the time this case was pending, he thought he had it nailed. That's right, this attorney actually thinks he can properly prepare a medical malpractice case without reading the medical records and without deposing a single witness. Well, you can read his legal arguments now and compare them to the medical record and see they're basically a sick joke. They're just a product of his own negligent and incompetent legal mind. Mr. Douglas's methodology of writing bullshit stories and calling them legal arguments only works if you don't have medical records to compare them to. And that's the position the judge was in. The judge only has what the attorneys provide. Kathleen M. Beck, however, had the entire medical record due to discovery, but Judge Lockman did not. So what's the judge looking at? He's looking at Mr. Douglas's distorted view of the facts and a prescription from the family doctor and the other 2 records I mentioned. That's it. So what's he going to do? He's going to dismiss the case, of course. Mr. Douglas cited no case law. That's another thing. An attorney who doesn't cite case law is guaranteed to lose because the other attorney has tons of case law to back up. This is just another example of how grossly incompetent Mr. Douglas is. Mr. Douglas knew from day one that Phyllis didn't see Dr. Hollin in the last 2.5 years, that her appointment was 2 years and 10 months. Simple common sense says that if the patient hasn't been to the doctor in the last 2.5 years, then pursuing the case based upon continuous treatment is a complete waste of time and is a guaranteed loser. The only way to get the case into the courtroom is to allege fraud. How do you allege fraud? Well, let's see. We have a concealed aneurysm, a time bomb operation, and 2 surgeons falsifying medical records. That's what you use. But that's not what Preston J. Douglas did. Preston J. Douglas just pursued a losing course of action from day one. He has no common sense, period, and he's incompetent. The fact of the matter is there was nothing whatsoever to lose by alleging fraud. If worse comes to worse, the case gets dismissed. And what did Preston J. Douglas wind up doing anyway? He winds up writing a complete bullshit story that destroys the case, calls it a legal argument, when all he had to do was present the evidence at face value. If an attorney's going to invent a bullshit story and call it a legal argument, the least he could do is invent a bullshit story that benefits his client, and Mr. Douglas could have just as easily alleged fraud, and there was nothing to lose by doing so. If worse comes to worse, the case gets dismissed anyway. But the fact of the matter is, once you claim that that smaller aneurysm has to be clipped, it explains everything. It explains why they concealed the aneurysm, why the operation was a time bomb, why they're falsifying medical records, why they're lying to the obstetrician, etc., etc. But that's not what Preston J. Douglas did. He just handled it like any other case. And as you can see, not only didn't he read the medical records, he just ignored them in their entirety. Dr. Hollin didn't lie to Phyllis for 8.5 years. Her husband found out later on. He didn't lie to the obstetrician. He reassured him that the repairs were holding up. His operation isn't a time bomb, even though Dr. Harupian says it is. He repaired 2 aneurysms using 2 different methods. So, another thing we noticed is that Preston J. Douglas is a defendant-biased plaintiff attorney. An attorney, any attorney, is supposed to be wholly dedicated to his client's position. Preston J. Douglas, however, is clearly dedicated to Dr. Hollin's position, and this makes him a disaster waiting to happen. Mr. Douglas doesn't know who the client is. To rewrite critical facts that are easily proven, such as lying to the patient and lying to the obstetrician, and then twisting them around that way and then failing to produce the medical records, this is defendant biased. All Preston J. Douglas did was twist the facts around to benefit Dr. Hollin, and he even went as far as claiming he falsified that document to the life insurance company because he said out of guilt. The notion that a doctor is going to falsify a medical record out of guilt is absurd. We have 2 doctors falsifying medical records. Doctors falsify medical records for one reason, because they're covering up something they did to the patient. The entire notion that he did it because he felt guilty is idiotic. Furthermore, plaintiffs' attorneys are not supposed to be making excuses and justifications for doctors falsifying records. Falsifying medical records is a fraudulent and malicious act. It's a lot worse than falsifying financial records, because the health and welfare of the patient, in this case the life of the patient, hinges on it. But as you can see, that's all Preston J. Douglas did. By doing this, he humanized Dr. Hollin also. The judge isn't stupid. The judge knows doctors don't falsify documents because they feel guilty. The judge probably doesn't even know what the hell to even make out of that document. But Phyllis was victimized by Dr. Hollin over an 8.5-year period in a highly deliberate and personal manner. He was able to see her at every single one of those appointments, look her in the eye, tell her he was perfectly fine, when in fact he was making the condition worse in order to cause her death. And his only interest in the matter was to ultimately see her autopsied at Mount Sinai Hospital to see how large the aneurysm grew and how much blood splattered on her brain. And the plaintiff's attorney is humanizing him by claiming he did it out of guilt. I mean, this is pathetic. And you will notice Preston J. Douglas doesn't even mention Dr. Klein's falsified documents. He obviously considers them to be completely irrelevant information. Well, if Preston J. Douglas thinks that Dr. Hollin falsified out of guilt, he must think all doctors falsified documents out of guilt. Because why would Dr. Hollin's falsification be different than any other doctor's falsification? So why would Dr. Klein be falsifying documents? He has nothing to feel guilty about. According to Preston J. Douglas, he repaired 2 aneurysms using 2 different methods, and the operation was a complete success. So why is he falsifying medical records? That's why Mr. Douglas's claim is totally idiotic. It boggles the mind that anybody, especially an attorney, could even come up with a line like that. But read the legal arguments yourself. That's exactly what he says. These legal arguments are totally idiotic, frankly. I could have gotten a better legal argument out of a class of 6th graders, to be perfectly honest. That's because a class of 6th graders would have at least read the medical records, looked up any words they didn't understand in a medical dictionary, and written a report about it. This case didn't need a so-called professional medical malpractice attorney to butcher and destroy the way Preston J. Douglas did. Anybody can do that. A random person off the street could have handled this case more competently than Mr. Douglas. That's because a random person off the street has simple common sense, would look at the evidence at face value, wants to win the case, and doesn't have all the ulterior business motives that Mr. Douglas has floating around in the back of their mind, namely, what do I have to do to nickel and dime this case to death and cut every conceivable corner that I can?